are watching and listening to Valley Media Works.
This program is simulcast on WRFP-LP 101.9 FM.
Public universities and the First Amendment. Invited speakers, campus protests, and disorderly conduct. A forum on UW-Eau Claire campus, October 25th, 2017, Hibbert Humanities Hall.
All right, well, welcome everybody to the Public Universities and the First Amendment. I have to be careful what I say here this evening as I'm looking out at 4 different video cameras, I guess. So hopefully I'm not somebody who's saying something that'll get me publicly protested. But what I want to do tonight is walk through First Amendment, what it says, and some Supreme Court case law in terms of the different doctrines the Supreme Court has put forth, different things that the Supreme Court says is protected speech or that isn't. And then after talking about those kind of general outlines of the First Amendment, to get into the recent region policy document that was passed earlier this month. And then talk about some things that I think it does well, some things that you might have some questions about, and then kind of turn it open to you for any questions or comments you might have. So, when we look at the First Amendment, of course, we're here talking about all of this because you've had some high-profile cases at public universities in the last few months, in the last couple of years in particular, where there's been someone who's been a rather controversial speaker who's been invited, and there's been protests or there's been an uproar as a result of that. And in some cases, speeches have gone on. In other cases, speeches at these college campuses have been canceled, or the speaker has decided not to go. And in cases where they have gone on, we saw a high-profile case just in the last week in a university in Florida, where it costs somewhere between $600,000 and $700,000 for security costs at the university. So you have all these competing interests: freedom of speech, how educational institutions conduct their business, the cost that these things entail. And so there's no surprise that we've seen some policies that have come up here that have been proposed or that have been enacted around the country to deal with these types of issues. So what are we looking at when we talk about the freedom of speech? When it comes to constitutional protections, the U.S. Constitution, the First Amendment, tells us Congress shall make no law abridging the freedom of speech. And that is, it's interpreted over time by the U.S. Supreme Court to mean more than just speech, more than just words, but to include things in print, to include symbolic expression, expressive activities, and that sort of thing. If you'll note, though, of course, by the very language of the First Amendment, it talks about Congress. Congress shall make no law. What about the states? Well, the Supreme Court for almost 100 years now has said that the Due Process Clause of the 14th Amendment protects the freedom of speech that is in the First Amendment. It protects it against state infringement. And the 14th Amendment does specifically talk about states. It doesn't specifically talk about the freedom of expression, but the Supreme Court has said that basically that word liberty in the 14th Amendment includes what is protected by the First Amendment in terms of freedom of speech. Taking it a step farther, the state of Wisconsin, like every other state, has its own state constitution. And you can see up there that there is a not a First Amendment, but a freedom of expression that is protected in the state of Wisconsin according to our founding document, telling us that we have the right to freely speak, right to publish our sentiments on all subjects, and that no law shall be passed to restrain or abridge the liberty of speech. Now that has a lot more in it in terms of text in the First Amendment, but the Wisconsin Supreme Court has said that protects the same thing that the First Amendment to the U.S. Constitution protects. So everything's kind of in lockstep here in terms of, if you're in the state of Wisconsin, the freedom of speech that exists under the federal constitution, under the state constitution, we've got the state Supreme Court telling us that those mean the same thing. Right? So for that reason, a lot of the cases that I'm going to reference as I go along tonight are going to almost all be Supreme Court of the United States cases. But those all apply equally here in Wisconsin because of the way our state Supreme Court has interpreted our state right to the freedom of speech. And then finally, in case there was any doubt, does this apply to public universities? The answer is yes. Supreme Court has said in a couple of notable cases, one Healy versus James in 1972, stating that state colleges and universities are not enclaves immune from the sweep of the First Amendment, and going on to say in a case called Papish versus Board of Curators a year later, that the mere dissemination of ideas, no matter how offensive to good taste, on a state university campus may not be shut off in the name alone of conventions of decency. And so the Supreme Court has said for over 40 years now, there's no question that not only does the freedom of speech apply to state governments generally, but it applies to public universities specifically. Okay. So again, all of these things that we're going to look at, talking about the First Amendment freedom of speech generally, this applies to public universities with equal force. So first, some kind of things to be aware of in terms of things that if the government does them, they would be infringing on the freedom of expression. Okay? Things that are, generally speaking, things the government shouldn't do. One thing the Supreme Court has said that the First Amendment protects as a general matter is that there can't be what are called prior restraints. Right? So the government can't say, well, yeah, you have the right to give a speech, but make sure that you submit it to us ahead of time for editing purposes, just so we can make sure that you don't say anything wrong. As a pretty heavy presumption under the First Amendment that prior restraints are almost always unconstitutional, and it's very rare that they would be that they wouldn't infringe upon the freedom of speech. Put it that way. Content discrimination is another concern under the First Amendment. As a general rule, government cannot say to you that certain content is off limits. Right? Now, as we're going to see, the place where the speech occurs, after we get through this slide, the place where the speech occurs can change that. And there can be places that are called designated public forums or limited public forums, where the content can be restricted to a certain extent. But as a general rule, I mean, if you're out there on Campus Mall and you are expressing yourself, that the government is hard pressed to come up with a reason why they could say that content is off limits. Okay. Similarly to that, there's viewpoint discrimination. With content and viewpoint discrimination, the government really needs what is called, it has to pass a test called strict scrutiny. That if it's going to enforce any discrimination based on what your viewpoint is or the content of your expression, that they would need to have a compelling interest, an interest of the highest order, and they would have to use the least restrictive means to accomplish that interest. That's a very hard thing to do. So as a general matter, government cannot tell you that your viewpoint is wrong, you can't express that viewpoint. Okay? And this, as is kind of one of the reasons why this recent policy document was at issue, is that this is most notably in the forefront when you have hate speech or offensive speech. But the Supreme Court has said in a number of cases that whether it is offensive, if it's upsetting or arouses contempt, if the society finds the idea offensive or disagreeable, that these things are still protected expression unless you have that compelling interest and that least restrictive means. Okay. In addition to different types of discrimination against ideas or viewpoints, the government has to be careful in terms of what's called overbreadth. Right? In other words, if the government's trying to prohibit a certain type of expression that it has the right to prohibit, and we'll see some of that shortly, there's certain types of speech that are not protected expression. If the government's doing that, that's fine, but they can't make that restriction broader than it needs to be. Because if they make a law that bans things that go beyond the point where they can ban things, and they start banning protected expression, then it becomes a First Amendment problem. Overbreadth is relatively rare in terms of a law being struck down as being unconstitutional, but it's another thing that the government has to be mindful of, to not run afoul of the First Amendment. Similarly, vagueness in terms of if the law isn't clear what's being prohibited and what isn't, that causes problems under the First Amendment because people don't know what they're permitted to do, what they're not permitted to do. And if that's the case, there's a potential that that right to the freedom of expression has been infringed upon. Now, related to these ideas of overbreadth and vagueness is a term of art for the First Amendment. So it's called a chilling effect. that if the government takes certain actions, the fear is that they will create a chilling effect on the freedom of expression, meaning that the government isn't directly stopping you from speaking, but you're afraid to exercise that right because you don't know what is actually illegal under a law or under a rule. And so you take yourself out of the game, so to speak. And that's what they mean by a chilling effect. Oftentimes that's a problem if the law is not clear. But it can also relate to the penalty that potentially be imposed. If the penalty is significant, even a law that's relatively clear, people might still decide, I'm not going to engage in expression that might get near that line because that penalty is so heavy. First Amendment scholar Frederick Schauer once wrote that the severity of the potential punishment magnifies the danger and hence the fear of an erroneous judicial determination. In addition to the objective harshness of a particular penalty, the length of a prison term, he's talking about in criminal cases, or the amount of a fine, the type of punishment itself may also influence the perceived severity of an incorrect legal judgment. Right? So there's this fear that people may have, and it may cause a chilling effect, that, boy, even if I think the law is clear, what if there is still some sort of trumped up charges that come at me, and I get found that I've engaged in speech that's not protected. I don't want to take that chance if the penalty is too high. That's another example of where the chilling effect can come in. Right? And then finally, something that the First Amendment says we have to be concerned about, and we have to make sure governments don't engage in what's called a Hecklers veto. A Hecklers veto actually kind of has two different meanings. There's a direct legal meaning of a Hecklers veto, which is when a speaker is giving a speech and maybe that speaker is saying things that are unpopular, controversial, and the crowd is getting angry, they don't want to hear these things, and there's a threat of violence. And in a direct sense, a Hecklers veto means that the members of law enforcement come in and they grab the speaker and they pull them out of there, maybe even arresting them. And there are concerns that the Supreme Court has with the Hecklers veto for obvious reasons. Right? The ability for the government to stop someone from speaking because of the reactions of a third party. And the Supreme Court has said in various cases, including relatively, it's not that long ago compared to some of these cases, but in Reno versus the ACLU in 1997, the government cannot confer broad powers of censorship in the form of a Heckler's veto upon any opponent of indecent speech. Right? And the Supreme Court really is almost saying in that case is that it's getting to this other definition of a Heckler's veto, right? The notion of being able to come in and to shout down a speaker to prevent them from speaking. Demonstrators might do this, might take over an event. And that is, it's a little different situation than all these other ones that we've talked about on this slide, because all these other ones, it's the government itself taking the direct action, saying, no, here we're going to punish you for speaking, or we're going to make a law that isn't clear when you can speak. And so it's government action that's at issue. And of course, with the freedom of expression on the Constitution, we're talking about government action. But the notion of a Heckler's veto, it brings in the third party. Whether it's this direct sense of the third party is seen as justification for the government to punish the speaker, or the third party just comes in and stops the speaker from saying what they were going to say. So again, that is kind of a term of art. It kind of has these two different definitions that you should be aware of here at the outset. So now we talk about all those things that government can't do. Let's talk about some instances where government can do things, because government actually can regulate a lot of things that you might say, as it turns out, depending on what you're saying, depending on where you're saying it, and depending on what the circumstances are around it. So the first thing to be aware of here is that the nature of the speech that you're giving matters. What the content is. Government can engage in content discrimination in terms of different types of topics that you could discuss. But the Supreme Court has said that there's a hierarchy that exists for the freedom of expression. At the top is the discussion of political and social issues. right? What should government do or what shouldn't it be doing? Who should be elected to political office? What should we do about this public problem that we have? These are all things that have the highest level of protection, and it's where any regulations on that typically have to pass what I talked about earlier, the strict scrutiny test. It's a tough test to pass for the government regulation. A tier below that is advertising and commercial speech. That's a form of expression where the government says we have more of an ability to regulate it, and we need to do that, and the Supreme Court agrees, because of the nature of deceptive or fraudulent advertising. And notice that kind of gives it kind of puts us in an interesting scenario where people selling products, they can have their expression limited to a much greater degree than people who are trying to, get your vote to get elected to office. That we don't allow the government to police what people running for office are saying the same way that we allow them to do so for those who are selling goods and services. And then at the bottom of this listing here is what we call unprotected speech. This is speech that can be restricted. It can even be punished criminally if you engage in this type of expression. All right? And there's more than what I list on here. These are just some examples. So one example is incitement to imminent lawless action. You get a group of people together, you give a rousing speech, and you're telling them, hey, let's go and burn down City Hall, that sort of thing, right? You are trying to get people who are like-minded to agree to go and commit some sort of violence, some sort of significant criminal wrong, okay? That's not protected speech, right? You can be prosecuted for that. Likewise, obscenity. And obscenity is one of those words that people sometimes throw around, and it's like, that's obscene. Obscenity, in terms of the First Amendment, means something that is appealing to the sexually prurient interest, is patently offensive because of that. And so these are, things that would be a level beyond pornography in terms of offensive, according to contemporary community standards. Libel and slander, making false statements of fact about somebody. If you make false statements of fact against somebody, they can file a lawsuit against you, right? You may have to pay them monetary damages, right? And that doesn't violate the First Amendment. Although it's harder to prove libel or slander if it's a statement against a public official or a public figure. The Supreme Court has said that we want to permit more debate and discussion around what public officials and public figures are doing. There's discriminatory harassment, right? If someone is engaging in a form of harassment, if it's various forms of discrimination, including sexual harassment, again, these are statements that people make, these are expressions that they have, but they can face consequences for that. It's not a violation of the First Amendment, the Supreme Court has said. True threats or intimidation, right? Threatening to kill someone. I'm going to kill you. And somebody says that and they really mean it. They're saying something, but it's not protected expression if it's a true threat. Now, if they're just kind of lobbing, kind of venting, and they don't really mean what they're saying, that's a different story. But if it's a true threat, if it's something meant to intimidate someone, then that's not protected speech either. And then as a last kind of example here of unprotected speech, stuff that's at the bottom of the hierarchy here, is fighting words. Fighting words is a situation where you're trying to goad someone into a fight, right? Trying to say something that will enrage them and anger them to the point where they want to fight you. I put this on here, and I put it on here last, in particular for a reason, which is that the Supreme Court has never overruled the idea that fighting words are unprotected speech. But the Supreme Court in recent years and other federal courts in recent years haven't found a whole lot of things that would fit that category. The fighting words is still something that's unprotected speech, but fighting words is not to the same level or degree in terms of Supreme Court case law as we might see in some of these other areas today, because there isn't a whole lot that would constitute fighting words, I think. And in part because fighting words at a certain point could potentially bleed over into a Hecklers veto situation. And there's a bit of a conflict there between the two, right? Because each of them is really about the speaker saying something that will enrage the listener, right? the thing that, if it is fighting words, it separates it from a heckler's veto and it would be protected expression, is typically what the speech is about, right? If they're directed at the person who is the listener versus if they're talking about an issue of social policy, which is going to be protected. So, that's a thing about the freedom of expression. Some expression gets more protection than others. Some gets none, depending on what it is. Now, beyond that, where the speech takes place matters. If you are in what's called a traditional public forum, if you are on, for instance, the campus mall out here, or a public sidewalk, a place that is open to the public, that is there for people would traditionally congregate to hold a demonstration or a protest or to go to try and convince people of their position, that's an area that has the highest level of protection in terms of places where speech can occur. We go down from there to what we call a designated public forum. A designated public forum is the type of place where the government can designate that expression here is for certain purposes at certain times, right? This room, for example, is a good example of a designated public forum. This room was reserved for this event today. And so it's reserved for this purpose, to talk about this topic. And if someone were to come in and they would say, hey, we'd like to instead take over your event and talk about something else. In a designated public forum, that becomes a difficult thing to do and say that that is protected by the First Amendment. A traditional public forum is a different situation, right? You can be out there on the campus mall, there's a lot of space, you can have different groups out there expressing themselves at the same time. But a designated public forum, just by the nature of the facility, if it can only hold one event at a time, the room can, that means that you can set up regulations in terms of reserving that space and having it be dedicated to certain things at certain times. And then finally we get a non-public forum. A non-public forum is a place like the county jail or a nuclear power plant or a place where it's not traditionally a place where people have had a right to protest, or it's not a place where the public has a general right to be anyway. And so there, depending on the circumstances, there may be very little protection or there may be no protection, depending on the context. Now, finally, what the government is trying to do or what it's trying to prevent matters in this calculus as well. We look at the freedom of expression. If the government is trying to prevent violence, including if it's a result of incitement to imminent lawless action, the government has more of a hand in being able to deal with that and not run afoul of the First Amendment. Similarly, if there's property damage that the government is trying to prevent, that is a concern that the government can have that would be counterbalanced against any First Amendment right. Encroachment on the rights of others. If protesters have a general right to be out on the campus mall, if they tried to block all the entrances to a building where a speaker was going to speak, that is probably going to cross the line in terms of what's protected expression if other people can't enter that building to do what they're doing. Or in another Supreme Court case, Hill versus Colorado as an example. The state of Colorado put in place a law that made it easier to gain access to healthcare facilities, particularly aiming at abortion clinics. Right? So that if abortion protesters were trying to block access, this law said that they had to stay at least 8 feet away to anyone who was entering that clinic with official business. Right? And there are restrictions on the signs that they could have and so forth. Those sorts of things the Supreme Court has permitted because they're counterbalancing First Amendment rights against other rights under the Constitution. Burdening government functions is another example. If you're stopping the ability of the government to function, that is going to cross the line, although it's pretty rare that we would get to that situation in most protests. And as a final example, time, place, and manner restrictions. So while it may be a protected right for you to have a protest, for instance, at noon, having that same loud protest at 2 a.m. raises certain problems from the perspective of the government often. And so the Supreme Court has said, well, there are these restrictions that can be oftentimes put in place in terms of time restrictions, in terms of the amount of noise that could be created if it's in a residential neighborhood and it gets late into the evening, for instance, that all of these things can also be restricted. And it's not against the First Amendment, again, unless there's some sort of viewpoint discrimination, content discrimination, that sort of thing that's being imposed. All right. So, those are all things to be aware of with respect to the freedom of speech generally. Now, before I jump into the specific policy, the policy document, I should say, from the UW Board of Regents, something to be aware of, which is disorderly conduct. Disorderly conduct is something which many jurisdictions have. It's a restriction on what people can do. And you can see the example here from the Wisconsin statutes in terms of what you would be prohibited from doing, what would be disorderly conduct. If that doesn't look exactly clear, well, it covers a lot of things. And it's not too vague, according to the State Supreme Court of Wisconsin and according to other courts in other states who have reviewed similar restrictions. But it is meant as a kind of a catch-all to keep order when there might be disorder, if you will. My favorite part of this is that it prevents boisterous behavior. I'm not quite sure what that is, but and I've never come across a prosecution for being boisterous that I can recall that I've seen anywhere. But obviously, this aims at violence as well. It aims at being abusive, indecent, profane, and even unreasonably loud. Right? And if you'll note, not only is it because you're in the state of Wisconsin are you subject to this rule against disorderly conduct, but right here on any University of Wisconsin property or buildings, they have a specific rule in the UW system code, administrative code, that incorporates this provision into what you're prohibited from doing here in any University of Wisconsin campus. Okay. And disorderly conduct, I point to this in particular because disorderly conduct is one of the things about this recent policy document that I think is front and center about the question of what's protected expression and what isn't. Okay. So, I know I just went through a lot there before I actually get into the policy. But there's a lot of background there to be aware of. So any questions about any of this at this point? Okay. Well, let's talk about the policy. Give you a little bit of background, a little bit of what the policy does, and then talk about things that I think the policy does well and things I think that raises certain questions in terms of what the policy does. There's part of the reason why the UW Board of Regents put in place this policy document and passed this was because the Wisconsin legislature was considering a change to state law, which would have required a number of things that were in this policy. And that Campus Free Speech Act passed the Assembly earlier this year, and it's currently sitting in front of the State Senate. And there's a real question of whether or not they'll do anything with it now, given that the Board of Regents has passed their policy document here. But that remains to be seen if there's going to be any follow-up from the State Senate at this point. And so at their meeting earlier this month, just a little less than 3 weeks ago, the Board of Regents entertained this policy document, and they ultimately passed it over just one dissenting vote. So what's in the policy? What does it say? What does it require? A number of things that I think are noteworthy. And of course, this policy document is several pages long. I'm just giving you some of the highlights here. This is not everything that's in it. But some of the main points. It does give a statement on the UW system's commitment to the freedom of expression, talking about how each institution within the system has a solemn responsibility not only to promote lively and fearless exploration, deliberation, and debate of ideas, but also to protect those freedoms when others attempt to restrict them. And it has several other statements along those lines in terms of very positive things to say about the freedom of speech. Now, one of the real points of public debate about the policy is what the policy document says it prohibits, or that will be prohibited once this becomes finalized through a change in UW system administrative code, which is that it prohibits certain types of misconduct, including disorderly conduct, that materially and substantially disrupts the free expression of ideas. And that's one of the things that caused some controversy in terms of what the policy is or isn't prohibiting, and should it be doing that. There's no question that's part of what the policy document says. So if someone violates that policy as a student, now if you violate any UW system rules for non-academic misconduct, you can be subject to a whole set of penalties that are listed in UW system administrative code. And of course, with disorderly conduct as an example, that also could be a violation of the state's criminal statutes, and you could face consequences in the state court system. But in addition to that, if you were to be found to have done this a second time, you could face suspension. A third time, you can face expulsion. And so those penalties are also one of the things that generated some controversy about this document. There's also reporting requirements by the university, reporting on things like making an annual report to the regents regarding efforts of the institutions within the UW system to uphold the principles expressed in the policy document regarding the freedom of expression. And reporting requirements in terms of if students have engaged in this behavior, found to have engaged in this behavior 2 or 3 times, and the penalties were not imposed. Although there's, I think, some lack of clarity about how much that extends. It's really just kind of a temporary reporting requirement until we get to the point when this is finalized in terms of UW System Administrative Code. But those reporting requirements are in there. And then lastly, new student orientation regarding freshman students or new transfer students, that they have to be provided with information regarding the freedom of expression during their orientation, is another one of the things that this policy does. Okay. So, that's the policy. Now, like any, or just about any public policy, I think there are some things that this does well and that are very, very laudable, very good, and there are some things that I would have some questions about regarding the freedom of expression. So what are some of the things I think are positive about this? And of course, I speak for myself, not for the institution when I'm up here, so let's keep that in mind. Promoting the right to the freedom of speech. That obviously that is a good goal in and of itself, and requiring institutions within the UW system to promote that value in various ways, including doing more in terms of educating students. I hope that that's more than just a handout at new student orientation, that there can be additional things that would be included in that. But at least at this point, that's going to kind of be up to each institution within the UW system how they're going to handle those sorts of specifics. It also works to protect the rights of invited speakers. Making sure that you don't have a Hecklers veto situation, either in the direct sense that the government has to extract the speaker, or in the more general sense that the speaker is prevented from speaking. And in either of those cases, it raises First Amendment questions, although more First Amendment questions are raised by the speaker being pulled out by the government, obviously, in particular if it's because or related to the viewpoint of the speaker. But ensuring that speakers can have their say, and that there can be that public dialogue is an important thing to have a statement that we protect. And that goes beyond the rights of the speakers to listeners. That if speakers are not permitted to speak, it affects the people who went to that event as well, who maybe wanted to listen to that speaker, maybe who wanted to challenge that speaker, maybe wanted to question what that speaker was saying. Particularly if it's an event where they had to pay to go in. That ensuring that people who want to attend these events have that opportunity. Likewise, one of the good things about it is on its face, this is a neutral policy. It talks about the right to the freedom of speech, whether it's someone who is coming in to give a speech, or someone who's a protester who doesn't want to hear that speech, doesn't like the speech. On its face, this is protective of all of these different interests. And one of the other things that it works to do, if you look through the policy and the specifics, is deterring what would be unprotected activities, right? Things that would not be protected by the First Amendment, trying to deter those things. discriminatory harassment, incitement to imminent lawless action, these sorts of things that are specifically mentioned within the policy document. These are not protected, and that these are not things that the universities need to promote in any way. Now, related to that is the idea of disorderly conduct. Although this, this fifth point here is kind of it's a positive thing, but it's also kind of some questions even raised with that. Because as you saw on the previous slide, we already have rules against disorderly conduct that apply statewide as well as within the UW system. Right? What this does is it added this extra wrinkle talking about how it prohibits this type of misconduct that materially and substantially disrupts the free expression of others. There's a real question about what that means, which kind of gets into my next set of things, which is what are some things that still raise questions. Before, as I was preparing for this speech, what I did is I went online. There's a database called LexisNexis where you can look through every state and federal appellate court decision that exists in the United States. And I did a search for this term, this phrase here, material and substantially disrupts the free expression of others, or related terms like material and substantially disrupts the free speech of others, all these kind of related terms. Couldn't find anything. Couldn't find anything that defines what that means. What does it mean to engage in that type of behavior, to disrupt the free speech rights of others? That, at least at this point, isn't clear. That might become clear as this is crystallized into administrative code or as individual universities, put in place how they're going to deal with these situations more specifically. But at least at this point, there's a vagueness question or an overbreadth question, especially with regard to protesters. If we're in some of those new rooms in Centennial, some of those big lecture halls on the first floor, where you have the windows, the big panel of windows on one side, what if you had a protest out there while a controversial speaker was speaking in one of those rooms? Would that be disruptive enough that someone could potentially face sanctions for that activity? If you're looking at, what if you had a protest that was going on in the hallway in this building, even if we decide, okay, we're going to shut the doors to muffle the sound, does that rise to the level where this would be a violation of the policy? If some of you in the back row back there, if you were to stand up and hold a banner that was, critical of what I was saying, and I said, well, I'm having trouble concentrating on what I'm trying to say here because of what they're saying in the back, is that being disruptive? If someone in the back of the room responds to a statement and responds for a little longer than maybe they should, and they shouted at me, what does that mean? Now again, I think in some of these instances, it's clear that this would not violate the policy, but in others, it does raise these questions, right? That these are issues that we need to clarify, I think, if we are to have the policy in place. And I mean, it's clear that this policy is going to be in place. I mean, it's something we're going to have to live with, at least for the time being. And so the question is, can this policy be repaired, or is this ultimately going to wind up in the courts and we're going to see it dealt with there? There's also a question about the penalties. Do the penalties, because they're significant, do they create a chilling effect on student speech? And I think the answer there, I think the answer is it depends, right? Because the penalties of suspension and expulsion, you have to have multiple offenses before it applies, and there are due process rights that apply in terms of when you are, if you've been accused of doing this, there's a process you'd have to go through, and all sorts of procedural rights that you would have. But nevertheless, if the penalty is that significant, are students going to say, well, I don't even want to take the chance that I might get charged with this, violating this policy. I'm not going to go and protest when I otherwise would. If that's the case, then we have the potential chilling effect problem. And the last thing I'll state here before I open it up for questions or comments, the viewpoint discrimination potentially in practice. And I think this is actually the weakest question up here. But it relates to actually that Hill versus Colorado case that I talked about earlier, about the abortion clinic protesters. And the Supreme Court there is stating that these were valid time, place, manner restrictions to say that protesters had to stay at least 8 feet away from unwilling listeners who were entering the clinic on official business, and they couldn't block the clinic's access points and that sort of thing. In a dissenting opinion in that case, Justice Antonin Scalia made the point that although on its face this law is written neutrally, right? It applies to anyone who's protesting at any healthcare facility in the state of Colorado. He said it's pretty clear that it was aimed at people who were of the viewpoint of a pro-life position, who were protesting at abortion clinics. And he says that's where it's been applied, that was the point of the law. And so, his argument in that case is that the law should be unconstitutional because it was engaging in viewpoint discrimination. Now that was not what the majority in that Supreme Court case found. They didn't find there was viewpoint discrimination. They found the law to be constitutional. But Justice Scalia's thinking here has the potential to apply to this situation, because almost all of these instances where you've had very controversial, inflammatory, or speakers who have engendered some level of protest and opposition that these policies are aimed at in Wisconsin and elsewhere, almost all of those speakers have been from a conservative political viewpoint, and almost all of the protesters protesting them have been from a liberal political viewpoint. And so I think if you follow Justice Scalia's reasoning, there is potentially an argument that could be made that if this is applied to people of particular views who are protesting, if that's really what the aim is, then there's a potentiality that's a First Amendment problem. Now, again, I think that's probably a weaker argument or a weaker question to raise compared to the chilling effect or the vagueness ones. But if this thing ever got into court, I would guarantee you that any lawyer taking the case who knows the First Amendment is going to at least throw that argument in there. And it's going to be in front of a court if that ever came to pass. They'd be looking at it. So with that, for an hour-long talk, I went about 40 minutes before opening up to questions. I think that's pretty good. So let me see what kind of comments or thoughts that you have. Give you a chance to exercise your freedom of expression here today. So, yes?
Can you talk about the difference between what's before the Wisconsin Senate and what the previous is?
Yeah. The two of them actually track pretty well. I mean, a lot of the differences are really stylistic or rather minor points. There's this question on the policy document, because what's in the document still has to officially go into effect in terms of state administrative code. So you've got these questions about the second or third offenses. Are these suspensions and expulsions mandatory or are they discretionary? And the state legislation was a little harder on those issues, and so you have some minor points of difference there. But what the regents stated, one of the reasons why they passed what they did here was that they wanted to show the legislature they were paying attention to what the legislature was doing, and they wanted to kind of get out in front of this and show them that, well, this isn't a problem. We can set our own policy, and you don't have to pass this law potentially. So at least that's some of the reasoning that they gave. So in that respect, there aren't a lot of major differences there. So others. Yeah.
Regarding an initial request to speak at a university, is the university obligated to let them speak as a First Amendment?
Well, who are we talking about in terms of who's making the request? You're saying someone from outside the university?
Yeah, someone from outside the university is applying, wants to speak on campus.
Well, here a lot of times what it will come down to is a couple of factors. Number one, what's the university's policy on outside speakers, right? And what are the requirements that they impose? And so is there a fee to use the facilities that they charge? Is there a fee if it looks like there's going to be some sort of increased security costs that they impose, these sorts of things? And universities, or public universities around the country, have the freedom to set those types of policies as long as they don't engage in that viewpoint discrimination, right? Because if they're saying, well, for a speaker who's saying the sorts of things you're saying, then we're going to restrict your access and that sort of thing, then they get themselves into trouble in the First Amendment. On the funding issue or the fee issue is if they allow, as a general matter, student organizations to invite in speakers that the student organizations are having come in on behalf of the organization, then they would be hard pressed to tell a student organization, no, we don't like what your speaker is saying, right? We don't want them to come here, because that would be a form of viewpoint discrimination, right? Unless you get to the point where they have a policy in place or rules in place about here's what this, there are fees that would be charged to handle security costs and facilities usage, the costs of the electricity and the maintenance and that sort of thing. And those can all be imposed, but if they're charging some people more than others, then they've got to have that compelling interest. They've got to be having the least restrictive means. They've got to pass that strict scrutiny test to do that. So as a general matter, they've got to treat everybody the same in that regard. So, yes?
Yeah, what does the reporting process entail? So I assume that someone was disruptive at a speaker's event, and then someone reports them later. What does that process look like?
Well, I mean, right now, because this is policy document rather than the actual administrative code, I think that there's a little lack of clarity there, but I can tell you that when it comes to the reporting requirements, this ultimately comes back to each university's chancellor in the UW system, right? It talks about the UW institution chancellor shall report to the Board of Regents regarding disciplinary process and decisions if students have engaged in this behavior. So ultimately that goes back to each institution's chancellor's office in terms of reporting that. Now, as is the nature of that type of job where the chancellor has a lot of things to do, the actual report might get delegated to and written by someone else and then submitted on behalf of the university. And that's kind of outside of what I deal with as a faculty member. I don't work over in administration. So the way that might work out on an individual campus remains to be seen. But it's ultimately each university, according to the policy document, would have to report that back to the system center. Yes.
I missed the first 10 minutes of this because I was at class, but I was just wondering if there was like a specific instance or some kind of occurrence that led the Board of Regents to think that they really needed to implement this kind of policy, and I was just wondering what happened or what was their thinking that we decided to use the legislation.
Yeah, Wisconsin has to this point been relatively quiet in terms of those events at universities. There was an incident relatively recently, several months back, Ben Shapiro at UW-Madison. There was a group that went to the front of the room and they were chanting and kind of took over the event temporarily, but then they ended up leaving and he had his speech go on. And of course there have been some more high-profile events at other places, particularly at UC Berkeley, some of the events that have gone on there, which has kind of led to this, not just Wisconsin. I mean, there are a number of other states that have either they're considering these policies, or they've been introduced in state legislatures or in front of public universities. And so it's those types of events that have led to this. Now, I mean, with any situation like that, there's a question: is it necessary or not? And of course, I think that's really a policy question, and people can disagree over, certainly. But one of the things to look at is what is the value added by any policy? What's the value added here? And does it get us anywhere in terms of adding this to disorderly conduct in terms of materially and substantially disrupting the free expression of others? And like I said, I think that remains to be seen because it's not exactly clear to me what that means. And if it's disorderly conduct including that, I guess the question is, why is that necessary if we have these disorderly conduct, which clearly, I mean, if someone's engaging in violent behavior that would disrupt someone's free speech rights, if someone is trying to take over an event, why wouldn't that be covered by what's already there? Right? Now, again, I mean, the reason in part comes down to this is a policy about the freedom of expression. And like I said, I think it's a good thing that we have reaffirmation about the freedom of expression, why it's important, why it's central to what universities do. And so I think there's no question that that's why this is added in here. But part of the questions I have is what exactly does this prohibit beyond what disorderly conduct already prohibits? And disorderly conduct, although it's relatively vague compared to a lot of other rules and criminal sanctions or criminal prohibitions. It's got a well-defined, well-worn, well-understood case law history dating back decades in this state and in other jurisdictions, right? What disorderly conduct is, what it isn't, where it runs into the First Amendment and when it doesn't. And this new wrinkle, at least now, it's not clear. Now maybe that can be worked out, but I think it does raise questions like the examples I gave earlier. Are those things that will be prohibited under the policy or not? Part of the way to fix that, of course, is to refine the policy, to have ongoing discussion and dialogue, educational events, and that sort of thing, right? And then we can have a better handle on this, because we don't want it to be that there's a chilling effect. We don't want it to be that people find out what's prohibited by the policy when they're punished or violating the policy either. Right? That's obviously problematic. So, hand back there, yes.
I was just wondering if it would be constitutional for the administration to put a blanket ban on any form of protesting within an event, just so they wouldn't even have to try to define what would be disruptive, and rather just say that they want to keep the protesting outside of the event?
Well, it depends on what you mean by the event.
Like within the little, like in this case, within this group.
Within the room, I think that the main thing the policy was probably aimed at, based on the background, based on the language, is that's this sort of scenario where a speaker is up in the front of the room, a crowd of people comes forward, chanting, holding signs, preventing the speaker from speaking. And so that would be something that, particularly in a designated public forum, encroaching on the rights of others. Not only, I think, is that very clearly something that would be in violation of this policy, but it's going to be in violation of disorderly conduct generally, right? You go to the front of the room, you try to take over an event. There's a speaker up there. The speaker has a case where the speaker might say, hey, what's going on here? Why are you taking over my event? Disorderly conduct in particular is aimed at is trying to prevent a disturbance, trying to prevent physical violence. And that sort of clash is the sort of thing that could very well happen in that situation. So I think that's something that you can't do now, or at least you could face some sort of discipline for that now. But if you're talking in a broader sense, there's this controversial speaker and coming to campus, and you want to protest on campus mall for the university to say there'll be no protests today. That would pretty clearly be a First Amendment violation, and that would raise a lot of problems.
I was more wondering if they, like your example of having a banner held up in the back, so just doing a blanket, like everyone will just sit here and listen, is that unconstitutional?
That gets us into a bit more of a gray area, right? I think all else being equal, that is something based on Supreme Court cases, particularly dating back to Tinker versus Des Moines, a case from the 1960s. Students want to protest the Vietnam War, and they wear a black armband with a peace symbol on it to class. They were ultimately suspended for that. They got their case to the Supreme Court, and the Supreme Court said no, it's protected expression, right? That this was a silent protest. It wasn't disruptive, and so that sort of thing is protected. And so I think all else being equal, it would depend on the context, depend on the nature. Is that sort of thing protected expression? If it's, well, you got a T-shirt on that says something critical of the speaker, I don't think that would rise to that level. But again, what if you're you're raising up some big banners in the back that say something? Let's say it's an inflammatory speaker, and you say something inflammatory about the speaker. That could potentially cross the line, depending on what the context is, what's being said, and is anything that's on that banner is that libelous? Is that slanderous? So there are some restrictions that can certainly be imposed there as well. But when are we to the point when it's, again, go back to the language of the policy, that it's materially and substantially disruptive of the free expression of ideas, of free expression of others? I don't know that a silent protest in the back of the room would do that. I wouldn't think so, based on what we've seen in terms of past Supreme Court cases that are relevant. But because it's not clear what that phrase means yet, we haven't seen a court interpret it, we haven't seen it defined by the state, that's something that has to be worked out, what's included and what isn't. I think these things are very clearly protected, right? Again, if you want to come to an event, ask questions of the speaker, hold a protest, hold a counter event, all sorts of things that clearly are very much protected by not only what the policy says here in terms of what's prohibited, but also these statements the policy has about protecting the right to the freedom of expression. It's in those closer cases where there's some questions, I think, that are raised. Okay, we're not sure yet. Now, again, I think that's it's a critique that can be offered, and it's a critique that comes with the caveat that this hasn't worked itself out yet. So, I mean, the UW system is still going to work out what these things mean. But as of right now, there's some questions at the margin. So, yes.
So I guess what got me interested in this was what prevents this scenario. This is applying strictly to speaking events. The speaker dislikes what a student said or what a student did in his event, his or her event, and applies pressure. So the school comes after the student using this policy, and it complicates that student's life, and there isn't precedent to fight like there is with disorderly conduct. So now this student is being drugged through different hearings or whatever that process looks like, and on top of going to school, this policy is a weapon being used against the student. Even if they beat this violation, it still has taken whatever amount of time, and there was no precedent, so it's basically just a free-for-all.
Well, I guess what type of example would you give?
So say a conservative speaker comes in, somebody else that doesn't agree with their viewpoint protests or has a silent protest in the back or whatever, the speaker takes offense or believes that this constitutes a disruption in their event, and they decide to speak to whoever they can speak to or that has some kind of authority to apply this policy to those students that were protesting and not necessarily in a disruptive way, just that speaker determined it was disruptive.
Right. Well, if something like that were to happen, there are a few things in play there. One is, if we don't already know at that point, if it hasn't been further defined, we're going to find out what it means to materially and substantially disrupt the free expression of others. But that's little consolation if you're the one going through it, right? Because even though the real heavy penalties here you're looking at on a second or third offense, and even though you do have the procedural protections that are still in place, nobody wants to have to go through that, right? Or at least most people don't. So some people want to go out and they want to see what, to kind of press the boundaries, and they don't mind facing these consequences. But for a lot of students, that's just not something they want to do. They don't want to risk suspension or expulsion, right? And so if you're in one of those scenarios, then it comes down to the chilling effect that really comes to the fore, right? That students may say, well, I don't want to bother with it, so I'm not going to chance it. And I think that's the real risk that we're talking about here, right? In terms of what the policy could do, what it means. Now, again, I think the number of cases like that are going to be really small where that would apply. I just think about all the speakers that we have had on this campus in the last year or so, and you think about, how many cases have there been where there's been disruption, where you've had some sort of issue. And so I don't know that there's going to be a lot of cases where it would apply, but where that boundary is where someone would have to be careful. I think all else being equal, the silent protest in the back of the room is probably not going to rise to that level. And even if the speaker tries to put that pressure on the university and the university wants to go along with it, again, you still have to go through, it has to be the second or greater offense, and you have to go through the procedural protections. And so there are things put in place to deter some sort of selective prosecution because they don't like the viewpoint being expressed or something like that. And that's a danger that exists anywhere, right, with just about any policy. I'm not saying that in either defense or opposition to this policy, but to say that that's a risk that we run. But it's reflective, I think, also in the policy itself, what it says it's there to promote. And the fact of the matter is that, regarding both the speaker and the protesters, in a free society where you have the freedom of expression, people are going to say things that you don't like. And so that doesn't just apply to the protesters who don't like the speaker, it applies to the speaker who maybe doesn't like the protesters engaging in that protest either. Yes?
Could you see the Board of Regents revisiting this rule sometime in the near future, perhaps be more specific, kind of clear up that vagueness for the...
No, I think that will probably instead get worked out in terms of changes to UW administrative code and implementation policies on individual campuses. At least that will be where the outlines are provided. My guess is that they're probably not going to revisit this because I think they think they've done what they needed to do. Right? They've told the UW system that this is what we want to promote within the UW in terms of a policy that we want carried out. And so I doubt that they're going to revisit this for that issue. Now, they may revisit the general issue. It was just a couple of years ago that they issued a previous document in support of the freedom of expression, so that if this topic generally comes up again, I wouldn't be surprised. But I don't think they're going to revisit this for this specific issue anytime soon. I don't think that's going to happen. I could be wrong. Yeah.
Let's say they do face a suspension or expulsion. What's the criteria, or what would be the criteria David standing?
In terms of, for this thing to get into court, you're saying? Standing in court?
Readmitted into the university. Or how would that affect the student with financial aid or anything else?
Oh, well, there would be lots of implications there. And, and again, I'm not an expert on the UW system policies so much in terms of, or any individual campus's policies in terms of suspension and expulsion and eligibility to be readmitted and that sort of thing. But I mean, at the very least, it means, you're going to be away from the university. It's going to be something that has the potential to follow you around in terms of your future schooling, and that goes to the chilling effect question. Now, again, I think the number of cases where that sort of thing would apply are going to be pretty small, based on Supreme Court case law, based on what the policy says. And so, I don't expect, again, how many students have been cited on this campus for disorderly conduct at a speaking event in the last year, 5 years, 10 years? My guess is that number is pretty low. It might even be 0. It doesn't happen very often. But if it does happen, then yeah, these are things to certainly be aware of, because the protection of the freedom of speech, those are there even if the violations may not occur every day, everywhere, right? Even if it is rare, it's not supposed to happen. And so we want to make sure we know where that line is so we don't get those violations. Yes?
Does the campus have some responsibility if the disruption is created by people who aren't students?
Well,
many of our speakers are open to the community.
yeah. I think that's the issue you saw down in Florida last week, right? That the university wants to make sure that there's a safe environment there, and it's this in an open society, campus. You're going to have people coming on campus every day who are not students, and if there's a threat of violence, then they have to up the security costs that are applied, because you just need more people there for security, and yeah, again, that can run hundreds of thousands of dollars. And I think it's important that we have the commitment to the freedom of expression, but there is a monetary cost to that in those types of cases. In most cases, there isn't, right? We all came here today, and I was able to speak to you, you're able to speak to me, and this effectively costs the university nothing more than to have the lights on, right? And in most cases, that's what happens. But in the cases where it is that type of inflammatory speaker, part of the gig with some of these speakers is to generate a lot of opposition, so it makes a big media story, and that just fuels the fire for whatever their cause is. That can get expensive, and then so I think that becomes an issue for universities to deal with, unless, if you're a public university, the state government itself says, okay, we're going to make sure that we have the funding available for the university to be able to deal with this. Because the university's got to take funding that they would otherwise use for something else, educational purposes, and it's going toward this. Again, I think that's a commitment that they have to make, but there's a cost to that, right? And the cost is, you may be giving up something else, and that can't be forgotten. All this.
the legislature that's in the state legislature right now, so did the legislation that's in front of the state legislature right now specify that it was students that needed to be regulated with the free speech, or did it say anybody?
Well, I mean, both the legislation as well as the policy document talk about, if protesters engage, regardless of who they are, if protesters engage in activity that's not protected, then they could face some sort of consequences. But obviously, it's most relevant to students because it specifies with students about the suspension and expulsion. And so that's, there's kind of that added wrinkle for students compared to anybody else. Because again, anybody, doesn't matter who you are, if you engage in disorderly conduct anywhere in the state of Wisconsin, you can face criminal sanctions, or depending on the jurisdiction, you could face an ordinance violation or you have to pay a fine. So those sorts of, regardless of who you are, if you engage in activity that fits that definition, then you can be punished as well. But obviously, when you're looking specifically at students, they're the only ones who would face suspension or expulsion. So it's kind of that added wrinkle for students compared to everybody else.
So do you think that the difference between the policy being mostly for students versus the legislation being like state law, would that be enough? Well, I guess you can't really speak to this, but do you think it would be enough to make the state legislature inclined to pass the law even though the policy is already in place?
No, because even the policy itself, it talks in general terms in various points. So, I think that would apply. And it would apply, in terms of what the policy does, what other policies do. And we've got this requirement specific to the UW system. And so, again, it may be the case the legislature takes this up, that the state Senate does, because they still want to see this passed. I think this took a lot of the reasons to do it away, because a lot of what the policies did, a lot of what the legislation did was require the university to do certain things, which they've done in this policy. Again, that doesn't mean that they might not still pass it, but I think it's a lot less likely now than it might have been, 2 or 3 months ago. Yes.
Do you believe, in regards to the fairly recent incident that occurred here off campus, where some students posted some very inappropriate messages on the front of their house, do you believe that would constitute as protected speech, or could that instead be cited as a form of obscenity and non-protected speech?
Well, I don't know that it would count as obscenity, because obscenity is actually defined in a very specific way, and
right.
Those types of offensive statements wouldn't typically be in that area. There's a question about, you're talking about the city of Eau Claire generally, and time, place, and manner restrictions, and restrictions on what homeowners can do, size of signs that can be displayed and that sort of thing. And so there are a number of those time, place, and manner questions that are in there. And with that incident, it's still not clear to me if it was really the case that, because I've seen conflicting reports in the media about this. Was it the case that when the police were there, that there was really an incentive given to them to take this down now, as opposed to what some other reports I've seen, which is that they had a conversation, and it was really the people who had that up that they were getting criticized on social media, and so they took it down because they saw that it was not a good thing to have up. I think there's a difference between those two, and that's a case where I don't really know what the facts are, and so it's hard to comment. But are there First Amendment questions that are raised there potentially? But without knowing more about what specifically happened, it's hard to say if that's a real problem. And of course, nobody's being punished by the government. And if that's the case, then you don't really have any First Amendment question at all. If, you have the right, that's part of what the freedom of speech means. You have the right to say everything you want, including things that are going to be very controversial, offensive, and so forth. And the government shouldn't be prosecuting you for that, but that doesn't mean that that's going to make you popular. And it doesn't mean that your friends have to like what you say, or that they even have to remain your friends. And that's part of, I think, if this, we get more education here on campus about the freedom of speech, if that's part of carrying out and fulfilling this policy, certainly there's an aspect here too. You have the right to do something, that doesn't mean that you have to exercise that right. And that would be a case where that might very well apply. Well, I guess we've got a couple more questions here, and I know we're past the point when, you know, you're used to watching TV, things are supposed to end in an hour. So I mean, if people have to go, yeah, I mean, it's certainly understandable you have to go, but I'm more than willing to stay here and answer questions.
Where does this policy stand on like social media protesting? So like, let's say for example, a speaker comes and I like live stream it on Facebook. I have a whole bunch of people coming, but I live stream it during the speaker's speech, and it's not on campus. I say I do it at Owen Park. Like, would I still be affected by this?
So you're saying that you are, where are you physically doing
Owen
this?
Park.
Okay.
Park, like right here.
So you're having a protest that's off campus?
Right.
Okay.
But I'm protesting the speech that's on campus.
Well then,
Using live stream.
yeah, I mean, at that point, I think that you would be, I mean, you would certainly be subject to those time, place, manner restrictions and all these other requirements that the city of Eau Claire may have, the state of Wisconsin has, and so forth. Now, there's a question, if you engage in certain activity, even if you're off campus, if you're a student, you could face non-academic misconduct, and you could violate the non-academic misconduct policy. So, you know, if you are, you know, engaging in criminal behavior, for instance, that could come back to hurt you, not in terms of this policy, but other existing policies that the UW system has. But in terms of the right for you to protest, again, as long as you're meeting any requirements that are in place, you know, if you're staying, you know, if you're in a public park and you're holding this protest, you know, and unless there's requirements in place for using a facility, you need to get permits or you need to get reservations and that sort of thing, then you're going to have that full panoply of protections that you would have in a traditional public forum. And so then there really isn't anything there, again, unless you're engaging in some sort of behavior that would fall under the non-academic misconduct policies of the university. And again, what all those policies are about, I mean, you can look them up. That's kind of outside of my area of expertise. I don't want to get too far into that because I don't want to tell you, you know, that you're okay doing something you're not doing. Because I don't know that policy very well.
Dr. Casper said I could.
Don't say that, no. So, yes.
There was recently a meeting of the NFL owners, GMs, and that sort of thing, and they were talking about the recent protest during the national anthem, and I think there was rumors or talks that they were going to possibly enforce a rule that would force the players to stand or fine them if they didn't stand for the anthem. Now, is that, since that's infringing on their freedom of expression, are they allowed to do that because they're a corporation, or how does that all work out?
Yeah, this is one of those cases where it's this slide that really, I think in many ways answers the question, although there's kind of a little bit of room to argue otherwise, which is that the NFL is not the United States government, the NFL is not a state. It's not an arm of the state. And so, I mean, they can put in place requirements that they're effectively their employees, these owners for each team, their employees have to carry out, and that's not in and of itself a violation of the freedom of expression under the U.S. Constitution. Right? Now, you can still argue, is that a just policy? Should the league have a different policy? Should U.S. employment law be different than what it is in terms of protecting those ability to protest that amongst the players? But it's not a First Amendment question directly. Except there's been one argument which I think is rather weak, but it's an argument worth discussing, which is that if the players are engaging in that protest at a publicly owned or publicly financed stadium, are they effectively then engaging in that protest on public land, and then because of that, should there be some sort of protection that comes in? Although I think that's an argument that applies much more so to other people who are there at the event, spectators and so forth, rather than the players themselves, because the players would be doing this or not as a condition of their employment, and so that kind of puts them in a different situation from someone who is there as a spectator, for instance, isn't being paid to be there. So I think that's a weak argument to begin with, and even weaker if it's applied to someone who works for, you know, what they would face as far as sanctions from their private employer. Again, we can talk about how that would be unjust or not, but I don't think it raises constitutional questions.
Maybe going off of that, like, it's not explicitly stating in their contract that they can't do X, Y, and Z, like, how is it not a virtue of their speech?
Well, I mean, you've got questions about contract law and, you know, the contracts that are set up. It's one of the areas that actually bring it back to universities. What's been argued, not in public universities, but private universities. The private universities effectively, if they are giving students documents that state, you know, we're committed to the free exploration of ideas and so on and so forth, even though the private universities are outside the scope of the First Amendment, and it's not a constitutional question, it's a question of contract law, and so that those free speech rights should be protected for students who are on private universities as well. Now, the extent that would apply here would come down to questions of contract law in terms of what the contract is with that player, what the collective bargaining agreement says, and whether or not, you know, changes are made to that agreement or a league-wide policy is implemented, which might supersede any individual contract, and whether or not that then violates the contract. And so you get into all these other legal questions that would have to be answered if they did that, certainly. But again, it's not the government doing it, so as far as the First Amendment, it's outside of the scope of that.
Are student organizations or the student senate, are they legally, regarding the First Amendment, are they considered part of the university, or are they a separate entity?
Well, if we're looking at student organizations are, they're made up of students, and so there are some First Amendment protections that certainly apply. The case the Supreme Court has looked at in the last 20 years, in particular regarding funding for student organizations, and stating that the First Amendments apply if student organizations, for instance, apply for funding and they're denied funding based on either their religious viewpoint or their political viewpoint, then that's a violation of the First Amendment. And so some of those rules apply. Now it gets a little murkier when you get into student government and what is that, you know, if they're making rules or if they're making policy suggestions to the university, you know, at what point are they the students, at what point are they policymakers, and that gets a little murkier. But for student organizations generally, I mean, that's where a lot of these cases come up, and in recent years, controversial speakers. It's a student organization that invites them on, and if a student organization generally are allowed to invite speakers to campus, which is something that you'd want to have on a public university, then to tell a university organization made up of those students, to tell one organization, no, you can't invite your speaker, and if that's based on viewpoint, that becomes a real big problem. So the student organizations, they do have that First Amendment protection according to the U.S. Supreme Court. It's a little different than the individual because there is a connection to the university, but I mean, these are organizations made up of students at the university, so it's ultimately the rights of the students in question here. In the cases that have gone to the Supreme Court, it have been students in the organizations who have filed the lawsuits against the university or against the Board of Regents for a university system and that sort of thing. All right, well, if that's all, and thank you all.
Newsworks is made possible by continuing community support. If you would like to volunteer or make a donation, please contact us via phone at 715-839-5067 or online at valleymediaworks.org.